So, guys, in case you don't know, Nnamdi Kanu sent a letter to Donald Trump. And also, in case you don't know, Donald Trump's attention has been brought to the happenings in this very country. And one of the happenings is the illegal trial of Mazin Nnamdi Kanu and also the illegal execution of judgment by Justice Omotosho on Nnamdi Kanu. And to start with, Omotosho had no legal basis. He had no legal foundation to execute a judgment of life imprisonment on Nnamdi Kanu because Nnamdi Kanu had no case to answer. Because even the Federal High Court in Kenya, where the arrest of Nnamdi Kanu took place, came out and said that Nnamdi Kanu was innocent and Nnamdi Kanu had no case to answer. And the very judgment of Omotosho on Nnamdi Kanu is a judgment that will be overturned and overruled because that very judgment from Omotosho lacked the basis of legality. And that very judgment from Omotosho was invalid because trying Nnamdi Kanu under a repealed law is against the constitution, it's against the 1999 constitution of this very country. So therefore, that very law had no basis to stand, and that very judgment from Omotosho had no basis to be executed. But it is a pity that Omotosho and Tinubu has transferred Nnamdi Kanu to Sokoto prison. But away from that, Donald Trump's action will be decisive because Nnamdi Kanu's letter is still with Donald Trump. But before then, there are two different videos I'll be displaying here for you guys. And after watching these two different videos, we are going to be heading straight to the appeal court's basis that will facilitate Nnamdi Kanu's release.
In the past few days, I've been seeing this story spreading everywhere on Facebook, WhatsApp groups, blogs, and political pages, claiming that the International Criminal Court, ICC, has asked Justice James Omotosho to bring out the written law he used to convict Mazi Nnamdi Kanu. The claim sounds bold, it sounds sweet, and it sounds like something people want to hear. But when you break it down carefully, the whole story does not stand on any solid ground. First, nothing like this has come from the ICC itself. And the ICC is not a hidden organization. Anything they act, they announce it openly through their official websites and media channels. International news houses like BBC, Reuters, or Al Jazeera also pick it up immediately. If the ICC truly confronted Nigeria on a major case like this, you would not hear it first on one Facebook page. You would hear it from the ICC directly because big institutions do not whisper. They make their actions public. What makes this kind of rumors spread quickly is the emotional tension around Kanu's case. People are tired, people are angry, people are hopeful, and anything that looks like good news jumps from phone to phone. But that is also how fake news gains power. Do not fall for it. When a story fits our emotions, we stop asking questions. Yet, this is exactly when we should slow down and think clearly. Think carefully to avoid being a victim of emotional exploitation. If you examine where this ICC story is coming from, you will notice the same pattern. Anonymous page, bloggers with no credibility, screenshots with no source, and claims that cannot be traced to any official statement. I am not perfect either, but you have to be very, very careful. Some even mentioned Jesha as the ICC head, a name that does not exist anywhere in the ICC leadership. When a story begins to fall apart at this basic level, it is a sign that the entire report is built on hearsay, not fact. Now, if this news was actually true, nobody would need to beg you to believe it. The ICC would announce it publicly. International journalists would cover it. Lawyers connected to the case of Mazi Nnamdi Kanu will confirm it. Human rights organizations will release statements immediately. That is how international justice works. It does not hide inside the rumor. It speaks loudly because transparency is part of the process. Transparency is the part of journalism. This does not mean that the legal issues around the Kanu's case are not important. In fact, they are very serious. Issues about constitutional rights, the method of his arrest, and the legal basis of the charges. But serious issues do not cancel the need for accurate information. If we all allow rumors to replace facts, it becomes easy for people to manipulate our emotions and control the public conversation with lies. So, if the ICC ever intervenes in this matter, the entire world will know. It will not be limited to one viral post. It will not hide in comments or screenshots. It will come out openly from ICC officials themselves, and every major media house will carry it. Until that day comes, the wise thing is to treat these viral stories as unconfirmed claims, not reliable reports.
Hello, Nigerians. My name is Lolo Neka Chimezi. Well, after MNK sentencing, if you go to social media, you will find out that some of our Yoruba brothers and sisters are the ones mocking the Igbos, laughing at us, mocking Nnamdi Kanu. Some of them are already started their propaganda, calling Nnamdi Kanu a terrorist. It's a shame that we call ourselves Southerners. But some of our Yoruba brothers have singled themselves out and have constantly betrayed the South. Sometimes we come out to say Northern dominance. It's not really dominating us. Or are some of us betraying us, giving us an edge? Let us go down memory lane and then look at how much the Igbos have supported our Yoruba brothers and how much our Yoruba brothers have supported us. We will not deny the fact that there were a lot of patriotic Yoruba people who have stood for the truth, but it's not enough. Because, as the saying goes, the majority carries the vote. When the majority of our Yoruba brothers are in the business of betraying, in the business of deceiving, living a double life, you will not blame people when they say Yorubas are not straightforward. So majority of the Yorubas has always enjoyed and supported the tribal, even the killing of the Igbos. And then I now made a survey and realized that the jihad that has been upon us, of course, the Southwest has been conquered by Islam because 75% of Yorubas are Muslims. This fact, they hid it for a very long time for we not to know. But the Muslim dominates them. And these Muslims share the same vision with some of our Hausa brothers who are pushing for the Islamization of Nigeria. And why the North are not really attacking the West like that is because they perceive that they have conquered the West already. I mean, I'm sure if the North will get up to 50% Muslims in the East, we won't have this opera. So their problem with the East is that they don't hate Igbos. Hausas will even prefer to deal with Igbos than the Yorubas. But they are our sin. Please make this go viral. I want our Yoruba brothers to hear this. Our sin is that we are Christian, and by extension, we are infidels. Of course, any opportunity, they should kill an infidel who doesn't believe in Islam.
So guys, let's head straight to the appeal court conditions that will guide Kanu's release. And one, the appeal court can void the sentence automatically. And I read, a repealed law has no legal force, so the Court of Appeal can strike out the conviction, declare the trial a nullity, in brackets, invalid from day one, free the defendants or order a retrial under the correct law. Courts have consistently ruled that you cannot try or convict anyone under a law that has been repealed. 2. The appeal court can rule that Omotosho lacked jurisdiction. If the law he relied on no longer exists, the judge appears to be exercising a jurisdiction he does not have. In law, jurisdiction is everything. If a judge acts outside it, the entire judgment collapses. Everything done becomes invalid. This is one of the strongest grounds Kanu's legal team can use. 3. The appeal court can say the conviction violates Section 36 of the Constitution. Section 36 of Nigeria's Constitution guarantees fair hearing, trial under an existing written law, clear charges under a valid statute. Using a repealed law violates all three. This gives the appeal courts enough power to overturn the sentence easily. 4. Kanu's lawyers can file for appeal on grounds of error in law, motion for bail pending appeal, motion for stay of execution. Using a repealed law strengthens all three applications. 5. Supreme Court, in brackets, if it gets there, will likely uphold that the law was defective. If the case goes to the Supreme Court, they will look at whether the law existed at the time of trial. If it didn't, the conviction becomes unconstitutional and invalid. The Supreme Court rarely tolerates convictions based on flawed legal foundation. And finally, 6. The Attorney General can step in. Under Section 174, the AGF can discontinue the case, in brackets, nolle prosecute. Step in if prosecution was done under a legally defective basis. And finally, order a review of the entire process. And it is clear, even to the blind, that the processes that Omotosho took to execute a judgment on Nnamdi Kanu for life imprisonment was false and illegal. So therefore, that jurisdiction of Omotosho to sentence Nnamdi Kanu to jail is invalid and dead on arrival. At this point, I will let you guys know what you feel about this in the comment section below. Do well to like this video, do well to share this video, and do well to hit the subscribe button below for more trending updates.